Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru, Tumarkin, the employment practice leader for Western Canada. We are here today to answer any and all questions you might have related to your employment rights. We're here for the next half hour to answer all questions that you might have. So put those in the chat. We're going to try and get through as many of those as possible. Basically, I work in employment law. That's all I do. So I'm very familiar with the law in Canada related to that. We answer questions for workers who are located in Ontario, BC, and Alberta primarily. That's where we practice. So feel free to put your questions in the chat. We're looking to get through as many of them as possible. I will reiterate, unfortunately, while we're waiting, today is the last day for over 8,000 workers at HBC, at the Hudson's Bay Company, who are being laid off due to a bankruptcy. We often get asked, what happens to our employment rights in a bankruptcy? Well, your employment rights don't disappear. You still have those rights in the sense that you're still owed your full severance, and that severance becomes a debt that the employer owes the employee. All right. The unfortunate way that bankruptcy plays into that is all the debtors, all the creditors, all the people that the debtor owes money to, generally only get a portion of their debt paid to them, if at all, based on what's left over to pay over the creditors after the unsecured creditors, especially after the secured creditors and the tax, the CRA have been paid off. So first, the CRA gets paid off. Certain employee amounts get paid off. Earned wages, earned vacation pay, that gets paid off first. Then you have, of course, you're going to have people who have, secured mortgages, secured loans. All of that get paid, and then whatever left for the unsecured creditors will go to them. So you're entitled to your full severance. Officially, but then like everyone who has a debt gets cents on the dollar generally, so it'll be your full severance multiplied by the cents on the dollar that everyone's getting, which means to say that if you are being terminated because of a bankruptcy, you are not without recourse. We can still help you out. There are certain programs available through the government to make sure that certain amounts of your severance are paid as well. We can help you through discover those programs and make your claim with the bankruptcy trustee. I know the times right now are quite tough for everyone. We're seeing an uptick in bankruptcies. But as I said, all is not lost. It happens a lot in employment law that people get terminated because the employer is going through some financial troubles. Does not mean that you lose your entitlement to severance or your employment rights. So if this is a situation that's happening to you, reach out to us. If you are looking to reach us, we're at employmentlawyer.ca. Employmentlawyer.ca. You have the website up on the screen there. We're always happy to discuss with you what your options are going forward. We have a question coming in from Twitter from Aniruda. Aniruda is asking, Google's AI says that you have to be employed for at least 5 years to be eligible for severance. That it is 1 week per year of service, and your employer must have a minimum payroll of 2.5 million. Is this accurate? Okay, so Google AI is referencing something called severance under a law called the Employment Standards Act of Ontario. So for whatever reason, the government, when they instituted the Employment Standards Act of Ontario, decided to call this payment that Google is describing, they decided to call it severance. And all that's done since then is confused everyone, including Google AI, as to what severance is. All right, so severance, as it's colloquially used, means the compensation you get when you're terminated. The legal name for it is pay in lieu of notice of termination. Okay, so pay in lieu of notice of termination is arrived at by looking at 4 main factors, which are referred to as the Bardell factors, if you want to plug that into Google AI. The Bardell factors list will give a range of how much severance you might be entitled to. So there isn't a law book that you can go to that says Aniruda gets X amount of severance if they're terminated. Okay. Basically, it's why lawyers are involved is because it involves looking at certain factors and comparing them to people similar to you. General rule of thumb, a judge will tell you that's not true. It's not how it's done. But general rule of thumb, if look at the trends, is that people get in the vicinity of about a month per year of service of severance. Okay, the severance is what it's colloquially called. What it really is pay in lieu of notice of termination. But then the Employment Standards Act of Ontario says that if you've been working for an employer for 5 years or more, and if that employer makes $2.5 million in payroll a year or more, then you're owed a week per year of service up to a maximum of 26 weeks. Now, you get that plus termination pay under the Employment Standards Act, and you may also still be entitled to severance pay under what's called the common law. Okay. So when we talk about termination pay and employment standards severance pay, we're talking about certain minimum entitlements that you get no matter what, right? But you may be entitled to even more compensation than that. And that's where we get to the standard regular severance that we're all talking about. So if you're confused, blame the Ontario government. When they called it severance in the first place, it's confused a lot of people since then. But if you're terminated, be aware that you're generally, across Alberta, Ontario, and BC, you're going to be entitled to more than 1 week of severance per year of service. And you're going to be entitled to severance whether or not you've worked for your employer for 5 years or whether or not your employer has a $2.5 million payroll or not, okay? You might be the only employee at that company, and that company might just be a corner store. You're still entitled to severance, okay? So Google AI, it's not a hallucination that they just gave you. They just gave you a very small portion of the whole story. That's took me 5 minutes now to explain what the whole story is. So be forewarned, Google AI is not an employment lawyer, all right? But thank you for bringing it up. If you have other questions you want to ask Google AI and then ask me if they got it right, I'm happy to do that as well. I'm here for that as well. We have another question coming in from Lily Foote. Lily Foote is asking, I'm an executive assistant, started working for a new exec who has said she cannot work with me. I've been doing it for 7 years and now they want to demote me because of this. What are my rights? They said I can move into a junior role, but will no longer be eligible for annual raises, etc. because I am in a senior position now. They will keep my salary the same. So Lily, this seems to me like you are being constructively dismissed. So a constructive dismissal is when your employer has not come out and said, we're terminating you, but have said, listen, the job that you have, we don't want you to work in that job anymore. We have another job for you, okay? And this other job is, a junior role, for instance. So presented with that, you have two choices. You can either say, okay, I'll accept the junior role with the conditions you've put on, or you'll say, no, I don't want that junior role. I want the role that I have. And your options, employer, are to either provide me with work in the role that I have or provide me with severance. All right. So the first question you have to ask yourself, Lily, is, are you willing to walk away from this job over this demotion and look for another role that is better suited for your abilities and is closer to what you were actually doing before they played around and changed the parameters of your job? If the answer to that is that, yes, I am ready to leave, I'm ready, I do not want this junior role, I've made up my mind, it's not for me, then reach out to us. Employmentlawyer.ca is how you get in touch with us, and we will explain to you how to get about accessing your severance because you've been constructively dismissed. All right. So constructive dismissals is a situation where your employer has said no, has not actually used the words "you're terminated," but by their actions are showing that they no longer want to employ you. Okay. It's a bit of a complicated situation to do on your own, Lily, because the first thing the employer is going to say, no, we haven't terminated you at all. In fact, we have offered you a job. And so you have to have some knowledge of the law and how the intricacies of the law work to guide you to your destination, which is to get your severance. So that's why I strongly recommend that if you're in a situation where you think you've been constructively dismissed, it's worth the time to schedule a call with us to go over the facts, and we can explain to you how to get from point A to point B. because you don't want to say the wrong thing. And the wrong thing you could say in this situation is you could, by your actions or inactions, you could be deemed to have accepted this junior role. Okay, that's the fear we have, that you're accepting the role and then you lose your right to claim constructive dismissal later. Say, for instance, they reduce your compensation by 50%. They put you part-time. And you tell yourself, I'm going to try it out for a year. And after a year, you realize it doesn't work for you. And the problem is, by then, by your actions, you've kind of let the employer on that you were okay with this. And so you may not be able to claim constructive dismissal. So you have to act quickly. You have to act in your best interest, and you have to have some support, I believe. So reach out to us. We're at employmentlawyer.ca. We're happy to help with this. We have a comment from a LinkedIn user indicating interesting. So I believe this is in reference to the question we had just answered previous to Lily's question here. Thanks for that. We have a question from YouTube from Darlene. Darlene is asking, my employer, hold on, where did it go? My employer is pushing me to move to one of their other locations. I don't want to add to the extra commute time as it will be a big change. Can they force me to move? Okay. So again, this could potentially be a constructive dismissal. It kind of depends on a few factors, Darlene. So it's going to depend on, is there an employment contract that you sign that says that they can do something like this? And how much of a commute are we talking about? Okay. So if supposing there's no employment contract that says that they can get you to change location at will, then really I would start saying that this could amount to a constructive dismissal if it's adding up to 30 minutes or more each way in your commute time. Okay. For instance, you can imagine if the other location was across the street from your current location, not a big deal. Probably the employer can ask you to do that. However, if the location was across the country, out of province, right, then it would be a lot harder for the employer to justify that they have the right to have you relocate, sell your home, take your kids out of school, move to another province, that they have the right to do that without your consent. And so it's a question of degrees, really. We're looking at, on the spectrum of things, how much more of a commute or a change to your life is this. And I would say once you start getting into the range where they're adding a half hour each way to your commute, that starts to look a lot like a constructive dismissal, in the sense that what you're basically saying is that, no, I do not accept that you can add an hour to my commute time, and therefore either keep me at the current location or provide me with severance. So those are your kind of options. I don't know if you've looked into it, Darlene. You can do it on Google Maps. Try to look on Google Maps at the times that you'd be going, right? I mean, you might look at 9 a.m. and it's busy rush hour traffic, but you're usually going at noon. Try to make sure you're looking at around the time that you're going to get a sense of how much time we'd be adding on to your commute there, to give you an idea of whether it would amount to a constructive dismissal or not. Vicky IY is asking, my employer is asking me to do something that I feel is unsafe. I don't have any safety training for this either. If I refuse, can they let me go? So, Vicky, it's very important, if you feel that what you're being asked to do is unsafe, that you don't do it. Okay, that you tell, first thing you do is you tell your supervisor or manager, whoever's nearest at hand, that you are refusing to do this unsafe work. Okay. Once you do that, the employer, that triggers some obligations from the employer. They have to, depending on the size of the company, have to get the joint health and safety committee involved, look at the hazard, determine whether this is actually safe or unsafe to do. If they determine that, Vicky, you're wrong, this is safe, go ahead and do it, you can still refuse. Okay. You say, no, I still do not agree that this is safe. I'm still refusing to do this work. When you do that, that triggers another obligation from the employer, who has now checked for themselves. They think it's safe. You think it's unsafe. We need to bring in a neutral third party. That neutral third party is an officer of the health and safety branch of the Ministry of Labor of the government, essentially. So a health and safety officer is going to come down to the work site, is going to examine the hazard, is going to make a determination whether it's safe or not. Okay. And then if it's determined that it is safe, that you have all the training you need to be able to do this safely, then you would have to do it. Okay. Now that's how things should operate if everyone was following the law. What sometimes does happen, you're right, Vicky, they'll tell you, listen, either you do it or there's the door. Okay. I can tell you that if your employer does that, they are creating a lot of problems for themselves, because you can contact that same health and safety officer and tell them, listen, I tried to refuse unsafe work and they terminated me. Okay. So of course, a few things flow from that. Firstly, that can't be a for-cause termination if you're just trying to enforce your rights to be free from danger at work. So that's a without cause termination. They owe you severance. Secondly, that might be a reprisal for having raised a health and safety concern in the workplace, which might entitle you to be reinstated into your job with back pay. All right. So you have a lot of options that kind of present themselves to you if that does happen. So if they do push and try to tell you, here's the door, unless you go and do this dangerous task, you have rights. You have a lot of rights. Governments throughout Canada, the management side, employee side, labor side, we're all very committed to making sure that everyone goes home safe at night at the end of their workday. All right. So the people err on the side of making sure that the workplace is safe. It's important that you take that as well seriously as well. You have rights. You have to rely on it. Right. No one can help you unless you help yourself by saying, no, I'm not doing this. I don't feel safe doing this. So that's the first step that has to happen. And then there's a lot of help from the government, from the legal system, from us lawyers to make sure that you don't suffer any adverse consequences from having refused to do unsafe work. So if you're given any trouble by your employer, feel free to reach out to us. We're always happy to help. We're at employmentlawyer.ca. employmentlawyer.ca. You have it there on the side of your screen. We have another question coming in from Anna from Reddit. How long is someone allowed to be off on sick leave before it is a frustration of contract and the employer can replace them? All right, so frustration of contract, essentially what it is, for those who are just joining or aren't familiar with the term, imagine a scenario, you go off on sick leave and you become permanently disabled. Imagine a scenario, you go on sick leave and then you become, quadriplegic. There's no way you'll ever be able to go back to work. So theoretically, while you're on sick leave, you're still employed with the employer, okay? They're not paying you, but they're holding your place in case, you get better, you come back, your job is still there, as is required under human rights legislation and certain employment standards legislation as well. So how long does the employer have to keep your place? All right. And that's what frustration of contract is all about. At some point, you've been off for so long and it's so unlikely that you'll ever return that the employer is allowed to say, we no longer have to keep your place. We're claiming that the employment contract has been frustrated. And what that means is that, through no one's fault, it's just the employment situation can't be performed. The employer wants to employ you and pay you wages in exchange for your labor, and you want to provide your labor in exchange for wages with the employer, but there's this intervening event, which is your disability, which is preventing that from happening. And because it's no one's fault, the employer can terminate you claiming frustration of contract, and you're not owed any severance, and you don't have to provide any notice of resignation. And so when does that happen? So it goes on a case-by-case basis, but you'll see employers start asserting that the employment contract has been frustrated after you've been off for 2-3 years on long-term disability or a medical leave of absence. Around that time, the employer should, if they're doing the things right, should send you a medical questionnaire to take to your doctor to get an idea of where you are medically and what's the likelihood of you returning in the foreseeable future. So that's the key question, all right? What is the likelihood of you returning in the foreseeable future, with or without accommodations? If it's a very low likelihood or no likelihood that you'll return in the foreseeable future and you've been off for 2-3 years at least, starting to look a lot like frustration of contract, okay? If there is a likelihood that you'll return in the foreseeable future, you might need accommodations, but you'll be able to come back with those accommodations. Even if you've been off 2-3 years, the employment contract has not been frustrated. We just need to be a bit more patient, and you'll be able to come back, in the next 2-3 months, 6 months even, with some accommodations. Things are looking up. I have had clients, they're challenged. They're like, it takes 2 years to see a specialist, right? To even just get a treatment plan from a specialist, right? So I feel a lot of a lot of people out there are in a bind, both employers and employees, because seeing a specialist takes so long to get the treatment plan that'll get you back to work, right? So if that's the case, you also have to be kind of upfront with your employer, saying, listen, I think there's a good likelihood that, or your family doctor could say this, there's a good likelihood that once I get on a treatment plan, I should have rapid improvements, but I'm waiting for either a surgery or to meet with a specialist or something like that. I need a bit more patience from you, employer. All right. So we'll look out for that when you get that letter from your employer, that medical questionnaire. Really, the question that's most important is what's the prospect of you returning to work in the foreseeable future? You have to understand that if the prospect of you returning is low or nil, then that was going to set up a frustration of contract. And you and your doctor need to be aware of that. This is not something you check through quickly on the corner of a table as you're heading out of your medical examination. Your job might be on the line here, all right? And people will tell me, well, what if my employer terminates me? I haven't been getting a salary. Usually what you'll lose is your benefits. Your benefits have usually been continued during this time. And, if you're on disability, you're probably making good use of your benefits. You might be seeing physio or counselors or additional medication, right? So you'll lose that, right? And that could be a problem. Now, if your employer terminates you and they say it's frustration of contract, but for instance, there is a chance that you'll come back in the foreseeable future, or, it's only been 6 months that you've been off on leave or stuff like that, you have the right to challenge that. You can say, in fact, no, employer, that is not frustration of contract. You've just gone ahead and terminated me, and so you owe me severance. All right? And so if that happens, and you're like, I don't think this is frustration at all, reach out to us, and we'll give you our thoughts on that. We deal with it all the time. So we're at employmentlawyer.ca. If your employer is alleging that your contract has been frustrated due to your disability, first thing you want to do is contact us, and we'll help you sort that out. All right? We have time. We have another question coming in from Rally Rider. Rally Rider is saying, how long can an employer place you on layoff for? Oh, before we get to that, sorry, Rally, I just wanted to specify one thing for Anna. So I said that if you're terminated due to frustration of contract, you're not entitled to any severance. And that's true, except that in Ontario, you would be entitled to certain minimum entitlements under a law called the Employment Standards Act, okay? Which is basically, I've been talking about this Employment Standards Act severance component. So that's 1 week per year of service if you've been employed for 5 years or more to a maximum of 26 weeks. And there's termination pay, which is a week per year to a maximum of 8 weeks, roughly, okay? So potentially you could get, a certain amount of money, but if it's not frustration because the employer, jumped the gun or whatever, then you might be entitled to a lot more than that, all right? So reach out to us no matter what, if that's being alleged by your employer. All right, so Rally Rider, sorry about that. I just want to get back to you here. How long can an employer place you on a layoff for? We're dealing with some disruption to our business, and a number of us were sent home, but we don't have a return date. Okay, so Rally Rider, I want to talk to you a little bit about a few things. If you've been here since the start of the show, you've heard the term constructive dismissal, Okay, so unless an employment contract says that they have the right to do this, or unless you've been laid off in the past and returned to work at the end of the layoff, your employer doesn't have the right to lay you off without your consent. Okay, so if this is your first time being laid off, and there's nothing in the contract saying that you have given your employer the right to lay you off, then from day one, you can treat that as a constructive dismissal. There isn't some inherent right to lay employees off with no pay in Canada, okay? Especially not in BC, Alberta, and Ontario. So if this is the first time you've been laid off, contact us if you want to go after your severance, because you do not have to accept this layoff, okay? And we can help you get your severance. And you don't have to wait the whole period that it takes before it becomes a termination, okay? That said, if you don't want to rock the boat right now and want to just stay home and enjoy the summer, your employer cannot keep you on layoff forever, okay? At some point, that layoff becomes an automatic termination, and you're entitled to pursue your severance entitlements, your termination entitlements. When does that happen? So it varies from province to province, okay? So in Ontario, it's 13 weeks unless your employer has, continued your benefits, has continued to make contribution to your benefits plan so that you can access your benefits during that time. That's the most frequently used exception. And if that happens, if they're extending your benefits, then it's 35 weeks that they can keep you on layoff, which is 8 months. Okay, it's a very long period of time. In Alberta, it's 13 weeks as well. And again, if they extend your benefits, who knows? They might be able to keep you on layoff forever. All right, it's very unclear the way the law is written. I would argue that it shouldn't be forever. But definitely, if you're in Alberta, you've been laid off, and your employer has continued your benefits, you need to contact us, because they might try to say that they can keep you on layoff forever, right? And then that becomes a huge complication. And in BC, it's also 13 weeks, all right? Unless you agree to let them extend it, okay? And if you let them extend it, then they can continue on extending it, indefinitely, okay? So at some point, it becomes a termination, all right? But if it's the first time you've been laid off, why wait these 13 weeks, which is 3 months, or 35 weeks, which is 8 months, or potentially forever? If the writing's on the wall, there's some difficulty with this company, they might not be around in 3 to 8 months. Let's get to the front of the line of getting you out of there with some severance, all right? So don't just assume that they have the right to do this, to park you at home with no pay for 3 to 8 months. They don't, all right? So give us a call. We'll be happy to discuss that with you. So if you're looking to reach us, it's employmentlawyer.ca. And the last question we have here is Libby Beans. And Libby is asking, are you able to get someone back into their job if they were let go for false reasons? So Libby, the short answer to that is mostly no, okay? So in BC, Alberta, and Ontario, the employer can terminate you for any reason, and even no reason, so long as they provide you with severance. And a court cannot order them to reinstate you, except in certain limited circumstances, okay? So if they terminated you because in a violation of your human rights. So for instance, we were talking about someone who was terminated because they were disabled. So then you could be reinstated. If they terminated you because you tried to raise health and safety concerns in the workplace, we discussed this earlier as well. Someone said that they were concerned that the workplace was unsafe, that the task was unsafe. If you're terminated for raising an objection to unsafe work, the Ministry of Labor can order that your employer reinstate you, okay? Those are the main exceptions. If you're terminated after you return from mat leave, for instance, or any of the other leaves that are under employment standards legislation, then you can be reinstated in those specific cases, okay? And if you are federally regulated, you might work for a bank or an interprovincial transportation company or a telecom, right? Or an Indian band, then you might have rights to be reinstated into your position if you're terminated on a without cause basis. So it's an exceptional remedy. It comes up quite often, but it's not just a run-of-the-mill thing that anyone can access. All right, it's got to be in certain specific scenarios, because the general rule is the employer can terminate you if they want to, so long as they provide you with adequate severance, adequate notice of termination. All right. So it depends on your specific circumstances, what happened. If you're wanting to speak with us, feel free to reach out. We can talk to you about whether we think it's likely that we can get you reinstated into your position. We're at employmentlawyer.ca. And Libby Beans is adding, thank you. Well, thank you as well. And thank you all for joining today. That was our last question for the day. It was a pleasure speaking to all of you. Great questions as well, as always. We have another show tomorrow with my colleague Karen Taraposky. We'll be answering questions live of anything related to employment that you have on your mind. Drop by, write her a line. We'll be happy to answer those questions. So my name once again is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the employment lawyer practice lead for Western Canada. And it was my pleasure to speak with you guys today. Thanks for tuning in, and we'll see you soon.